You're home alone. You hear a knock on the door. It's the police. They say they got a call about a possible emergency. Someone thought they heard yelling. The officers say they need to come in and make sure everyone's okay. You say no one's in danger, everything's fine. But the officers push past you anyway. They walk through your house. They see your gun collection on the wall. They see ammunition on the table. They start asking questions. Do you have permits? Where did you buy these? Are they registered? You say, this is my home. You can't just come in without a warrant. The officers say, yes, we can. It's called the emergency aid doctrine. And on January 14th, 2026, the Supreme Court made it easier for police to use that excuse. The case is Case versus Montana, and the court ruled unanimously that police can enter your home without a warrant if they have an objectively reasonable belief someone needs emergency aid. No probable cause of a crime required, just a reasonable belief. And who decides what's reasonable? The police. This decision affects every gun owner in America, because once police are in your home, they can see your guns. They can ask questions. They can start investigations. And you need to understand how this works and how to protect yourself. Quick question before we continue. Are you subscribed yet? Because what I am about to reveal is how a Fourth Amendment case about warrantless searches affects your Second Amendment rights to own guns. The Supreme Court just made it easier for police to enter your home, and gun owners are uniquely vulnerable. Hit that subscribe button right now because you need to know how to protect your home and your guns from warrantless police entries. Here's what happened and why it matters. The case started in Montana. Police received a call about a possible domestic disturbance. Someone reported hearing yelling from a house. Officers arrived. They knocked. A woman answered. The officers asked if everything was okay. The woman said yes, everything's fine. But the officers insisted on coming inside to check. The woman refused. She said, you need a warrant? The officers entered anyway. They said they were concerned someone inside might be in danger. Once inside, the officers found evidence of a crime. Not a violent crime, not an emergency. Just evidence that led to an arrest. The defendant challenged the search. She argued the entry violated the Fourth Amendment. The district court agreed and suppressed the evidence. But the government appealed. The case went to the Supreme Court. And on January 14th, 2026, the court ruled unanimously in favor of the police. The court said the emergency aid doctrine allows warrantless entries when officers have an objectively reasonable basis to believe someone inside needs immediate aid. The court emphasized objectively reasonable. That means it doesn't matter if the officers were wrong. It doesn't matter if there was no actual emergency. As long as the belief was reasonable at the time, the entry is constitutional. The court also said no probable cause of a crime is required. This isn't about investigating crime. It's about rendering aid. So the normal Fourth Amendment protections don't apply. Officers don't need a warrant. They don't need probable cause. They just need a reasonable belief that someone might need help. And that's a very low bar. Now here's why this matters to gun owners. Once police are in your home, they can see everything in plain view. If you have guns on display, they see them. If you have ammunition on the table, they see it. If you have accessories or parts lying around, oh, they see those too. And seeing those items can lead to questions. It can lead to suspicion. It can lead to investigations. Even if you've done nothing wrong, having police walk through your home uninvited creates risk. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the exact steps to take if police show up at your door claiming an emergency and you need to protect your Fourth Amendment rights without looking suspicious. Subscribe right now so you don't miss it. Now let's talk about the emergency aid doctrine in detail because you need to understand how it works. The doctrine has been around for decades. It's based on the idea that police have a duty to help people in danger. If officers reasonably believe someone needs emergency medical aid, they can enter without a warrant to render that aid. The classic example is police see someone collapsed inside a house through a window. They can break in to help. No one disputes that. But the doctrine has been expanding. Courts have applied it in situations where the emergency is less clear. A welfare check because someone hasn't been seen in days. A noise complaint because neighbors heard shouting. A call about a possible overdose based on secondhand information. In all these cases, police have argued they had a reasonable belief someone might need aid, and courts have upheld the entries. Case versus Montana pushes the doctrine even further. The Supreme Court said officers don't need to be certain there's an emergency. They just need a reasonable belief. And that belief is judged from the officer's perspective at the time. If later it turns out there was no emergency, that doesn't matter. The entry was still valid. This creates a huge problem because police can manufacture reasonable beliefs. An anonymous tip, a vague complaint, a noise that could be anything. All of these can justify entry under the emergency aid doctrine. And gun owners need to be especially careful. Because if police enter and see guns, that can trigger additional scrutiny. Now, quick legal note. This is educational information, not legal advice. If police show up at your door claiming an emergency, the law is complicated. Your best bet is to consult with a criminal defense attorney and a Fourth Amendment lawyer who can advise you on your specific situation. Do not make decisions based solely on this video. Let me give you real-world examples of how this plays out. Imagine a gun owner named Mike. Mike lives alone. He collects firearms. He has an AR-15, a few handguns, a shotgun. All legal, all properly stored. One day, Mike's neighbor calls the police. The neighbor says he heard a loud bang from Mike's house and he's concerned. Police arrive. They knock. Mike answers. The officers say they got a call about a possible emergency. Mike says everything's fine. I was just moving furniture. The officers say they need to come in and make sure no one's hurt. Mike says, no one's here but me. I'm fine. The officers insist. They push past Mike. They walk through the house. They see Mike's gun collection. They start asking questions. Do you have permits for these? Have you bought any guns recently? Where do you store your ammunition? Mike feels violated. His home was invaded without a warrant. But under Case v. Montana, the entry was legal. The officers had a reasonable belief based on the neighbor's call. It doesn't matter that there was no emergency. The entry stands. Now, imagine a different scenario. Imagine a woman named Lisa. Lisa owns a handgun for self-defense. She keeps it in a bedside safe. One night, Lisa is watching TV. The volume is loud. Her downstairs neighbor complains to the building management. Management calls the police for a welfare check. Police arrive. They knock. Lisa answers. The officers say they got a call about loud noises and they want to make sure she's okay. Lisa says, I'm fine, just watching a movie. The officers say they need to come in and verify. Lisa refuses. She says, you don't have a warrant. The officers say we don't need one. This is a welfare check. They enter. They walk through Lisa's apartment. They see her gun safe. They ask what's in it. Lisa says that's none of your business. But now the officers know she has guns. They run her name. They check if she has permits. They verify the safe is legal. Lisa did nothing wrong. But police intrusion created stress and hassle, all because of a noise complaint and the emergency aid doctrine. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about how to protect yourself. First, understand you have rights, but exercising them is complicated. If police show up claiming an emergency, you can refuse entry. You can say everything's fine, no one needs help, please leave. But if officers insist and enter anyway, physically resisting is a bad idea. You'll be arrested for obstruction. So what do? You document. Pull out your phone and start recording. Say clearly, I do not consent to this entry. I'm not giving you permission to search my home. You are entering against my will. That creates a record. If evidence is found and you're charged, your lawyer can challenge the entry. The recording proves you didn't consent. Second, be very careful about what you say. If officers ask questions, you have the right to remain silent. You should use it. Don't answer questions about your guns. Don't volunteer information. Say, I'd like to speak with an attorney before answering questions. That's not suspicious. That's smart. Third, store your guns properly. If police enter, you don't want guns lying around. Keep them in safes or locked cases. Keep ammunition separate. This minimizes what police can see in plain view. It also protects you from theft if your home is ever broken into. Fourth, know your state laws. Some states require permits for certain guns. Some have storage requirements. Make sure you're in full compliance. If police enter and see your guns, you want everything to be legal. No gray areas, no questionable items. Fifth, consider getting a doorbell camera. If police show up, the camera records the interaction. If they claim you gave consent or there was an emergency, the video proves otherwise. This is powerful evidence in court. And sixth, network with other gun owners in your area. If police are using emergency aid doctrine aggressively, others have probably experienced it. Share information, warn each other, and support organizations that fight Fourth Amendment violations. Let me give you another scenario. Imagine a guy named Tom. Tom is a competitive shooter. He has dozens of guns, all legal, all properly registered. One day, Tom doesn't answer his phone for 24 hours. His girlfriend gets worried and calls the police for a welfare check. Police arrive. They knock. Tom doesn't hear them because he's in the shower. Officers decide to enter because Tom's not responding and there might be an emergency. They walk through the house. They see guns everywhere, on racks, on tables, in cases. When Tom gets out of the shower, police are in his living room. Tom is furious. The officers say, we were concerned about your welfare. Tom says, I'm fine. You had no right to enter. But under Case v. Montana, the entry was legal. The officers had a reasonable belief based on the girlfriend's call and Tom's lack of response. Tom's guns were all legal, but now police have seen his entire collection. They took photos. They documented what he owns. That information goes in a database. Tom feels like his privacy was violated, and he's right. But the law allowed it. This information could literally save you from a warrantless search if you know how to handle police at your door. Subscribe now because my next video explains the exact script to use when police claim an emergency, and you need to refuse entry without getting arrested. Hit that subscribe button. Now let's talk about the implications of this decision. Gun control advocates probably aren't thinking about how this affects gun owners. but gun rights advocates should be concerned. Because warrantless entries based on vague emergencies can lead to discovery of legally owned guns, and that discovery can trigger investigations, especially in states with restrictive gun laws. If you live in California, New York, New Jersey, or Massachusetts, police seeing your guns creates risk. They might question whether you have proper permits. They might question how you acquired them. They might question whether you're in compliance with magazine limits, assault weapon bans, or storage requirements. Even if you're fully legal, the scrutiny is invasive and stressful. Now let's talk about dissents. Wait, there were no dissents. The decision was unanimous. All 9 justices agreed. That tells us the court views this as a straightforward application of existing doctrine. The emergency aid exception is well established. The court is just clarifying how it applies. But unanimous doesn't mean uncontroversial. Civil liberties groups are concerned. The ACLU put out a statement saying this decision could be abused. Police could use emergency aid as a pretext for warrantless searches. And gun rights groups should be concerned too, because gun owners are vulnerable when police enter their homes. Now let's talk about what to do if police have already entered your home under this doctrine and discovered your guns. First, document everything. Write down what happened, what the police said, what you said, what they saw, what questions they asked. This information is critical if you're charged with anything. Second, do not talk to police without a lawyer. If they want to question you about your guns, say I want an attorney. Nothing else. Don't try to explain. Don't try to justify. Just ask for a lawyer. Third, if police took photos or seized anything, get copies of the reports. You have a right to know what they documented. Fourth, consult with a Fourth Amendment lawyer. If the entry was improper, evidence discovered can be suppressed, but you need a lawyer to challenge it. And fifth, consider filing a complaint. If police entered your home based on a false or exaggerated emergency, that's a problem. You can file a complaint with the department. You can also consider a civil rights lawsuit under Section 1983. Police can be held accountable for violating your rights. It's not easy, but it's possible. Let me give you one more scenario. Imagine a woman named Sarah. Sarah is a single mother. She owns a handgun for protection. She keeps it in a safe in her closet. One day, Sarah's ex-husband, who has a restraining order against him, calls the police. He claims Sarah threatened to hurt herself. Police arrive for a welfare check. Sarah answers the door. She says, "I'm fine. My ex is lying." Officers say they need to come in and verify. Sarah refuses. Officers enter anyway. They search the house. They find Sarah's gun safe. They ask what's in it. Sarah says, "A handgun, legally owned." Officers verify her permit. Everything checks out. But the ex-husband accomplished his goal. He got police into Sarah's house. He created a record of her owning a gun. Now he can use that in their custody battle. This is how the emergency aid doctrine can be weaponized. People with bad intentions can make false reports to trigger police entries, and gun owners are particularly vulnerable to this tactic. Look, I spend hours every week reading Supreme Court decisions, analyzing Fourth Amendment cases, and tracking how warrantless search doctrines are expanding so you know how to protect your home and your rights. The least you can do is subscribe to make sure you never miss critical information like this that could save you from a warrantless search. Subscribe right now. And if you found this helpful, share it with every gun owner you know. Most people don't realize how vulnerable they are to warrantless entries under the emergency aid doctrine. They need to know. Spread the word. Remember, this is educational information based on the Supreme Court's decision in Case versus Montana. It is not legal advice for your specific situation. The law on warrantless entries is complex and varies by jurisdiction. Always consult with a criminal defense attorney and a Fourth Amendment lawyer if police enter your home without a warrant. Stay informed. Know your rights. Document everything. And understand that, as a gun owner, you're at heightened risk when police enter your home for any reason. Protect yourself, protect your guns, and protect your Fourth Amendment rights. Because once you lose them, they're almost impossible to get back.